Imagine a courtroom where silence screams louder than any testimony.
Mm.
A space where choosing not to speak can weigh just as heavily, maybe even more heavily, than the most damning evidence.
It's a powerful idea, isn't it?
It really is. Today, we're diving deep into a legal puzzle. It comes from the Hong Kong Special Administrative Region's Court of Final Appeal back in 2002.
Right, the case FACC 5 of 2001.
That's the one. And it's this fascinating look at what happens, legally speaking, when someone accused of a crime decides just to remain silent in court.
Exactly. And our main source here is the judgment document itself. It's quite a significant case.
And who are the key players?
At the heart of it, you've got two individuals. There's Mr. Zhang Sanni. He was a former deputy general manager at the Bank of China.
Okay,
And the other is Mr. Li Si, a businessman.
got it.
And their appeal, well, it really boils down to this one fundamental question. Did the judge back at their original trial make a legal mistake?
How so?
Well, the judge suggested that because they chose not to testify, their silence actually made it simpler for the court to conclude they were guilty of bribery.
So they argued that infringed their right to silence.
Precisely. That's the core argument, that it went against their basic right to remain silent.
Okay, let's back up a bit then. What were Mr. Zhang San and Mr. Li Si actually accused of doing? What landed them in court to begin with?
Right. So the whole thing centers on a pretty big loan. We're talking US $40 million.
Wow.
Yeah. Mr. Li Si's company, Shenghong Investment Co., Ltd., was seeking this loan from the Bank of China. It was for a development project in Zhengzhou, a big city in mainland China.
And Mr. Zhang San's role at the bank?
He was important. He was the head of the commercial development department. So basically, he was in a critical position for evaluating and recommending loans exactly like this one.
Okay, so you have the loan application, the bank official. Where does the alleged bribery come in?
Well, the timeline is key here. The loan agreement was finalized in September 1997. But while they were still sorting out the details of how the money would actually be released, the drawdown schedule, Mr. Li Si makes a payment to Mr. Zhang Sen.
How much are we talking?
HK $3,696,706. So, a substantial amount.
Definitely. And where did this money come from?
It came via two checks from a company called Hong Kong International Development Company, or Guozhan, and this company was solely owned by Mr. Li Si.
And after this payment, the loan money was released.
Yes, the loan was subsequently drawn down.
Right. Okay, that certainly looks suspicious on the surface. Now, when it got to trial, did either of them get up and explain this payment in court?
And that's a crucial point for this appeal. No. Neither Mr. Zhang San nor Mr. Li Si chose to testify during their trial in the regional court.
Complete silence in the courtroom itself.
From them, yes. However, and this is important, both of them had given detailed accounts earlier. During interviews with the IC...
Independent Commission Against Corruption, Hong Kong's anti-graft body.
That's right. And video recordings of those ISAC interviews were actually played as evidence at the trial. The judge considered these statements, as potential evidence both for and against them.
So they weren't totally silent on the matter beforehand. What did they tell the ICX? What was their explanation for this nearly HK $3.7 million payment?
Okay, so Mr. Li Si, the businessman, he told the ICAC the money was Mr. Zhang San's share of profits. Profits from trading shares in a company called Kadik Shenzhen.
Okay.
He claimed that both his company Shenghong and his other company, Guozhan, had been involved in this trading, and that the money for Guozhan's part came from, Guozhan itself.
And what about Mr. Zhang San, the bank official? What was his story to the ICK?
His version was slightly different. He said he had recommended the Kadik stock initially as an investment, but, he claimed, other directors at Shenghong objected to the company buying the shares.
So the company didn't buy them.
According to Mr. Zhang San, no. He said Mr. Li Si then asked him, personally, to take up the shares instead.
And he agreed.
He said he did. And he claimed he offered his wife's deposit certificates as, security against potential losses. The deal being he'd keep any profits.
Okay, so their stories, they overlap a bit with the stock trading idea, but they definitely don't quite match up, do they?
Not perfectly, no. There were discrepancies. And the trial judge, he ultimately found their explanations to the ICE unconvincing. He pointed out several things he considered improbable in their accounts.
So he rejected their out-of-court explanations.
He did. He concluded the evidence pointed strongly towards bribery, and crucially for our discussion, he referred to an older case, Lam Sua v. the Queen.
And what was the significance of that reference?
He basically said that because Mr. Zhongsan and Mr. Li Si chose not to get in the witness box and give their explanations under oath in court, well, they couldn't really complain if the court drew negative conclusions.
Those adverse inferences you mentioned.
Exactly. Especially, he added, if their silence made it easier to draw those inferences. So an adverse inference here basically means the judge felt it was more reasonable to lean towards guilt because they hadn't offered that counter-explanation in court.
So the judge was effectively saying their silence in the courtroom strengthened the prosecution's argument.
That's certainly how the defense saw it, and that's the absolute core of their appeal.
Was there anything else in the trial outcome?
Yes. Just as a side note, Mr. Li Si was also found guilty on a separate, smaller bribery charge. It involved giving a Lunar New Year lacee packet, a red envelope with money, to another bank employee who was handling the loan processing.
Okay. So convictions for both, and then they appealed up through the system.
Correct. They appealed, and eventually their case landed before the highest court in Hong Kong, the Court of Final Appeal.
And the sole issue, the only thing they argued before that top court, was about their silence during the trial.
Exactly that. Their single ground of appeal was that the trial judge had made an error in law, specifically by saying their failure to testify made it easier to draw those adverse inferences. They contended this violated their fundamental right to remain silent.
This really hits on a fundamental aspect of the legal system, doesn't it?
Okay.
The right to silence. So normally, say in a jury trial, what are juries told about a defendant choosing not to testify?
Right. Well, in jury trials, there are pretty established standard instructions judges usually give. They've evolved, drawing from cases like R.V. Bathurst.
And what do these instructions emphasize?
They really emphasize the protections for the accused. The jury is told very clearly the defendant has absolutely no obligation to testify. Zero.
It's their right.
Absolutely. It's their right to stay silent. And the burden of proof, it's entirely on the prosecution. They have to prove the case beyond a reasonable doubt.
And the silence itself.
Crucially, the jury is told they cannot assume the defendant is guilty just because they didn't testify. Silence isn't evidence of guilt. It doesn't prove anything the prosecution claims.
But there's a nuance there, isn't there?
There is. The instructions often also point out that, well, because the defendant hasn't testified, they haven't provided any evidence from their side under oath to contradict or weaken or, explain the prosecution's evidence.
So the jury can't use the silence as evidence? But the fact remains they haven't heard the defendant's side of the story in court to counter the prosecution's case.
Precisely. It's a very delicate balance the law tries to strike. You protect the right, but you also acknowledge the reality of trying to figure out what happened based only on the evidence that was presented and tested in court.
It seems like a fine line.
It is. And while silence isn't an admission, the absence of a denial or explanation in court, especially when the prosecution evidence seems strong, can leave the prosecution's version looking, well, more plausible, perhaps, because it's unchallenged by the person who presumably knows the most about it.
Has the thinking on this changed over time?
Oh, definitely. Historically, judges had a lot more freedom to comment, sometimes quite strongly, on a defendant's silence. But over the years, particularly thinking about fairness and the right against self-incrimination.
Like in famous cases?
Yes, cases like R.V. Bentley in the UK and the principles laid out by Justice Devlin in the Dr. John Bodkin Adams trial really pushed towards greater restraint to protect that right more robustly.
But are there still situations where a judge can make stronger comments?
Yes, there are guidelines, often linked to the case R.V. Martinez-Tobon. These suggest stronger comments might be permissible in specific circumstances.
Such as?
Like if the defense case involves facts that directly contradict the prosecution's evidence, and these facts would clear the defendant. And they are things that, realistically, only the defendant would know about.
So very specific conditions.
Very specific. And even then, anything the judge says can't undermine those basic instructions. The right to silence remains. The burden of proof stays with the prosecution. It's not a green light to just say, well, they didn't talk, so they must be guilty.
Are there examples where courts have said stronger comments were okay?
Yes. The Hong Kong case HKSR v. Launder was mentioned. The court felt stronger comments were justified there because the defendant didn't explain some very large suspicious financial transactions.
Okay, so bringing it back to Mr. Zhang San and Mr. Li Si's appeal. What was the core argument made by their lawyer, Mr. Blanchflower?
Right. Mr. Michael Blanchflower, SC, their senior counsel. He argued something quite fundamental. He said the whole idea that a defendant's silence could actively strengthen the prosecution's case, going beyond just leaving the evidence unchallenged, was, well, constitutionally unsound.
On what basis?
He pointed directly to the Hong Kong Bill of Rights, Article 11(2). It guarantees that no one can be forced to confess or testify against themselves.
The right against self-incrimination.
Exactly, and the broader right to silence that flows from that. His argument was essentially, if the court can draw stronger negative conclusions because you stay silent, doesn't that indirectly pressure you or even compel you to testify? It undermines the right.
Did they look at how other countries handle this? I think you mentioned Canada earlier.
Yes, absolutely. Mr. Blanchflower specifically cited a case from the Supreme Court of Canada, R.V. Noble.
And what did the Canadian court say?
Well, the majority in R.V. Noble actually supported a very similar interpretation. Under the Canadian Charter of Rights, they suggested that allowing these kinds of adverse inferences from silence could indeed put improper pressure on a defendant to give up their right to silence.
So Canada's top court seemed to agree with the appellant's argument.
The majority did, yes. However, crucially, the Hong Kong Court of Final Appeal in this case ultimately disagreed with the reasoning of the R.V. Noble majority.
Oh, interesting. So why did the Hong Kong court disagree? What was their perspective?
They found other judgments more persuasive, specifically a dissenting opinion by Justice Gleeson in an Australian case, Azopardi and Davis, and also the reasoning from Lord Dipluck in a Singapore case, Ha Tua Tau v. Public Prosecutor.
And what did those judges argue?
They argued that, look, in a system where you are not compelled to testify, and that's key, no one is forcing you. It is permissible for a court, using common sense, to draw inferences from silence. Even if not testifying feels like a risky choice because the prosecution case is strong.
So the fact that there's an incentive to speak doesn't mean you're being compelled to speak.
That's the essence of their reasoning. The Hong Kong Court of Final Appeal sort of viewed the right to silence as this umbrella term. It covers various specific rules against compelled self-incrimination. But just saying right to silence doesn't automatically tell you exactly what constitutes compulsion or precisely when an inference from silence crosses the line.
It's about the specific rules and context, not just the general phrase.
Exactly. They felt you need to look at the specific situation.
The defense also brought up how earlier Hong Kong cases interpreted a key ruling from the Privy Council, right? The Sharnpal Singh case.
Yes, they did. The defense argued that some Hong Kong cases, like Sung Shui Sing v. the Queen, had perhaps stretched Lord Devlin's comments in Sharnpal Singh a bit too far.
What was Lord Devlin's point in Sharnpal Singh?
He'd said, essentially, that a court can draw proper inferences from the evidence if a defendant doesn't offer an explanation for incriminating circumstances. The defense argued this didn't mean silence could make those inferences stronger or easier to draw.
Just that the inferences could be drawn from the evidence itself if left unexplained.
That was their interpretation.
Yeah.
But the Court of Final Appeal didn't buy it. They read Lord Devlin differently.
How so?
They suggested that Lord Devlin's remarks did imply that, depending on the specific facts, silence could actually add weight to the prosecution's case. That the lack of an explanation in court could make the incriminating interpretation of the facts more convincing.
Okay, and what about those Australian cases the defense relied on? Weissensteiner, RPS as a party.
Right, they leaned heavily on those. The Court of Final Appeal paid particular attention to Weissensteiner v. the Queen. They actually quoted quite a bit from it.
What was the key principle from Weissensteiner that resonated with the Hong Kong court?
Weissensteiner basically said this: if the prosecution presents evidence pointing to guilt, and there are facts that could explain or contradict that evidence, and those facts are peculiarly within the defendant's knowledge,
Things only they would know.
or things they could reasonably be expected to know and explain. If the defendant doesn't offer that explanation, the court might find it easier to accept the prosecution's evidence. Not just because it's unchallenged, but because the absence of the expected explanation can help resolve doubts about the prosecution's case.
So the silence isn't proof itself, but it can make the existing proof seem more solid.
That's a good way to put it. The Weissensteiner judgment was very clear. Silence is not evidence. It's not an admission. You can't infer guilt just from silence. But it distinguished that from drawing inferences based on the prosecution's unchallenged evidence, where common sense tells you the defendant probably could have offered an innocent explanation if one existed.
And the Hong Kong Court of Final Appeal agreed with us.
Yes, they explicitly stated that the principles in Weissensteiner accurately reflected the law in Hong Kong.
So their position was essentially, in certain situations, silence can be factored into how you weigh the prosecution's overall case.
Exactly, especially when you have, a strong body of evidence from the prosecution that really seems to demand an explanation, and the defendant is likely the person who could give it.
Did they agree with everything in the Australian cases?
Not entirely. They did express some disagreement with a fine distinction made in the Azzopardi case. The Australian court tried to differentiate between facts solely known to the defendant versus facts just known to them. The Hong Kong court found that distinction a bit too rigid, maybe impractical.
Okay, so taking all these complex legal principles, how did the Court of Final Appeal apply them back to the specific facts of Mr. Zhang San and Mr. Lindy C's situation?
Right, they brought it back to basics. What did the prosecution need to prove? They needed to show that Mr. Li Si offered and Mr. Zhang San accepted that money, the advantage, as an inducement or reward related to Bank of China business. Bribery, essentially.
And was there direct proof, like a recorded conversation saying, here's the bribe?
No.
Yeah.
No direct evidence like that stating the purpose of the payment. The prosecution's case was circumstantial.
Oh, built on what?
Built on the context. The commercial relationship, Mr. Zhang San's senior role at the bank, the sheer size and unusual nature of the payment happening right around the loan finalization with no clear, documented, legitimate reason.
So the prosecution was asking the court to infer the corrupt purpose from these circumstances.
Precisely. They argued the only logical inference was that it was a bribe for favorable treatment on the loan.
And the court noted the defendants knew they had to explain this.
Yes. The Court of Final Appeal pointed out that even Mr. Zhang San and Mr. Li Si recognized they needed an explanation. That's why they gave those detailed accounts to the ICC in the first place.
But the trial judge had rejected those ICC explanations as untrue.
Correct.
Oh.
So the Court of Final Appeal reasoned. Given that their prior explanations were deemed false by the trial judge, their subsequent failure to get in the witness box at the trial under oath and offer any explanation, well, the trial judge was entitled to consider that silence.
Entitled to consider it how?
As something that further strengthened the inferences already suggested by the prosecution's circumstantial evidence. The silence, in the context of the rejected stories and the suspicious circumstances, made the bribery inference more compelling.
So putting it all together,
Yeah.
what was the final decision? Did the appeal succeed?
No, it did not. The Court of Final Appeal dismissed the appeal.
Which means their original convictions stood.
That's right. The convictions for bribery were upheld.
Okay, wow. That's a lot to unpack.
Yeah.
So for you, listening to this deep dive, what's the big takeaway here?
I think the main thing is this. The right to remain silent is absolutely fundamental. It's a cornerstone of a fair legal system, a key protection. No question about that.
Right.
But, as this case shows really clearly, exercising that right, choosing not to testify in court, isn't always neutral in its effect. It can have consequences in how the evidence is evaluated.
Especially when the prosecution case seems strong.
Exactly. When the prosecution presents compelling evidence that seems to cry out for an explanation, and the defendant is the person likely to have that explanation, their silence can, in those specific circumstances, add weight to the negative inferences drawn from the evidence.
It's crucial to stress, though, the silence itself isn't guilt.
Absolutely vital. It never equals an admission of guilt. It's not evidence in itself. In this case, remember, it wasn't just silence in a vacuum. It was silence after their previous explanations to the ICAC had been rejected as false, and in the face of suspicious circumstances needing clarification. That combination was key.
It really makes you think, doesn't it, about the power of silence, not just in court, but everywhere. You know, that old saying, a lie shatters a family truth, finishes it. Here, the rejected explanations were perhaps the lie, and the silence that followed allowed the court to arrive at what it considered the truth.
It's a complex interplay.
It really is.
Yeah.
And it makes you consider the ethical weight of silence, right, in our jobs, with our families, legally. When does silence protect you? And when does it, maybe unintentionally, speak volumes against you? How much does our expectation that someone should explain themselves shape how we see things?
And that leads to a really provocative question for you to mull over. In these kinds of cases where the prosecution evidence looks strong and seems to need an answer, is it truly fair for a court to draw stronger negative inferences if the defendant stays silent?
Or does that put too much pressure on them, effectively weakening that fundamental right to silence?
Exactly. It's a tough balancing act, with really strong arguments on both sides, and it's something legal systems are still grappling with around the world.